Our job as professional journalists to be made easier. If we look at the First Amendment
and the way it was written, it says that Congress shall make no laws.
It doesn't say it shall make no harmful laws that get in the way of what the press does. And it doesn't say that it ought to put laws in to help it out. It says no laws. And I'm with Justice Black. I think that the Founding Fathers knew what they meant when they said no. They meant no. Okay. At the bottom, then, my own opposition to shield laws, since I finally come down on a side against it, is based on the view that such legislation would be unconstitutional. And I agree again with Hines that a citizen's duty in some cases transcends a reporter's right to protect a source. I don't want to go to jail either, incidentally. Okay. Further enactment of shield laws would of necessity lead to judicial determination of who is a journalist. And if we start licensing journalists, I would rather that journalists sat on the board than judges. Here, for example, is the definition of professional journalist that's contained in the New York Shield Law, which at one time at least was considered one of the more foresighted. It says that a professional journalist is one who, for gain or livelihood, is engaged in gathering, preparing, or editing of news for a newspaper, magazine, news agency, press association, or wire service. I hope those of you with radio interests notice that you've carefully been left out. It defines a newscaster in another section of the bill. So obviously radio people are not professional journalists, but they are newscasters in New York. That argument gets settled quickly. But I wonder what this particular definition says about the freelance. If, as a freelance writer, I have no obvious and clear connection with some newspaper, magazine, news agency, press association, or wire service, I clearly fall outside the protection of this shield law. Or do I? Now here again, I think we're asking the courts to make a decision about this. In Iowa, this would become a crunching question for those of us at Iowa State because we ask our students to be interns on newspapers. We ask them to do it during a summer. Part of the material they have to collect to get a degree from us is to work for a summer as a reporter or intern on a newspaper, at least for some of them. Now, during that particular period, would we have this trouble if we had a shield law? Perhaps Mr. Small can answer my question. Suffice it to say that here the judges are deciding who is a professional journalist. I don't think we ought to I don't think as professionals we ought to allow government to come in and trot all over our rights to define who constitutes a journalist or not. We got to remember, I think, that if the government says we can, it can also say we can't. If it gives us a shield, it can take it away. Okay, I don't think that any argument can show that shield laws are necessary conditions for excellent performance, despite whatever new situations we may be confronting today. The good newsman, to the extent that he's willing to dig and do his job, can continue to expose corruption in government, dig out the facts, and present them to his audience. I doubt that the ethical newsman, and maybe that's a key adjective, the ethical newsman with any sense of responsibility will write any sort of expose piece with information based solely upon the comments of one source. If he does, he's certainly not, he doesn't fall within my category, at least, of journeyman newsman. Okay, I don't believe we have to have any law to back up our pledge to a source that we will keep his name confidential. I almost fell off the chair when you told the story about the guy showing the name. That's terrible. As I say, I don't want to sit in jail either, but if I tell somebody I'm not going to say who he is, I've given my word, and that's an end of it. And I don't need a law to tell me that, okay, King's X will keep you out of jail if you do that. Thing I would like to see is journalists continue to do, those of them who are, the job of digging and reporting that has been occurring. The end.
Thank you. Our final panelist on the Shield Law is Lowell Fort. He received a BA in journalism with distinction from the University of Iowa and an MA in communications from the same school. He's now a third-year law student at the University of Iowa Law School, former news editor and editor-in-chief of the Daily Iowan, the University of Iowa student newspaper. He's done public relations and speech writing for the University of Iowa administration. Cited by the Associated Press managing editors for journalism, contributing to an exemplary report for the coverage of the campus disturbances following the Martin Luther King shooting. Received second place for Spot News Writing Iowa Association Press Managing Editors Contest in 1969. Mr. Fort.
Thank you. I think I wanted to start off by saying one thing. The three panelists before me have, I think, all said something about, or at least two of them, that no good newsman will have to rely on confidential sources. Well, unfortunately, that's not necessarily true, because if you are doing a story like Clark Mullinoff usually does, he doesn't have to rely on confidential sources because he has lots of sources. But when you're dealing with a story like Mr. Caldwell was writing about, the Black Panthers and their ideology and their attitudes toward our government, or the kind of story that Mr. Brandsburg was writing about, two men in the drug culture converting marijuana into hashish, those you have to have confidential sources to get that kind of pulse on the subcultures of our country, or those people who we see as different or unique or revolutionary. And without the protection, those kinds of stories may go by the wayside. As Hugo Black said in the New York Times case of 2 years ago, the press was to serve the governed, not the governors. The press was protected so that it could bear the secrets of government and inform the people. And I think that's the important thing to keep in mind, is inform the people. Now, I sat down not too long ago to try to get a feel for the status of the First Amendment and what's going on in the states as far as privilege statutes. And I did end up with a very concise statement of 5 or 6 pages, about 35. And it's like trying to grab a piece of air from a room and tag it. There are, if we're going to talk about privilege, we can talk about what Dean Wigmore has set up as specific qualifications that he thinks are important for the creation of a privilege. And that's that the communication must originate in confidence, and that they will not be disclosed, and that the element of this confidentiality must be essential to the satisfactory maintenance of this necessary relationship, and that the relationship must be one in which the opinion of the community ought to foster, and that the injury that would inure to the relationship by disclosure would be much greater than the benefit gained by disclosing the source of the information. From that outline have been formed the constitutional arguments on why we need a press shield from the First Amendment. And that's one, that newspapers, or the media generally, require informants to gather news, and that confidentiality is essential to the creation and maintenance of this relationship. And continual forced disclosure of information and sources will, one, destroy the sensitive relationships between news persons and their informants. It will impede the free flow of news and information. And thirdly, and consequently, will run counter to the public's benefit for full availability of the news. Now, these arguments have been frequently presented, but only rarely to justify an absolute immunity from disclosure. And this is probably because there's a long line of case law history that it recognizes the concept that the First Amendment is indeed not absolute. And that's primarily because of the areas of defamation and sometimes contempt of court, where disclosure of information that should be kept secret in a trial or something like that cannot be disclosed. And then from these arguments, though, they do say that since such a fundamental right is involved, the privilege should not be divested except on a showing of compelling need of overriding importance. And this would require more than just a showing of a general need, or that there's a general relationship between what's wanted or what's being investigated and what is believed the news person has in his notes or his tapes. The argument requires that that relationship be very substantial. Factors that might contribute to a finding of substantialness would be the unavailability of other methods to secure the information, the relevance of the information sought, and the reasonableness of assuming that that reporter or the news person has, in fact, got that information, and the importance of that information to the success of the investigation of the proceeding. Now, the contra-arguments to a constitutional argument that the press shield is, in fact, under the First Amendment, is that the journalist privilege was never recognized at common law, and that everyone has a duty to appear and testify before a grand jury, and that generally evidentiary privileges should be restricted. These are the arguments that went before the Supreme Court of the United States last year in Brandenburg versus Hayes, United States versus Caldwell, and in Re Pappas. They were decided together under the name Brandenburg v. Hayes on June 29, 1972. Now, once you have a familiarity with the history of the First Amendment, the decision comes as no great surprise that no constitutional privilege exists. The decision, of course, here comes a surprise, I'm sure, was written by Justice White with Chief Justice Burger announcing it. And besides Burger, the other Nixon appointees that approved the decision, the other three, were, of course, Blackmun, Rehnquist, and Powell. Powell wrote a short concurring opinion. Justice Stewart wrote and was joined by Brennan and Marshall in dissenting opinion, and Justice Douglas, in his true and fine form, wrote a separate opinion saying that not only does privilege come from the First Amendment, but it is indeed absolute. For the majority opinion, what they basically did was sat down those arguments contra to any argument that it is, in fact, protected by First Amendment, that there is no common law privilege granted to newsmen, and that the First Amendment is, in fact, not absolute and has been broken down in certain areas. You cannot write what you want to write, and you cannot always say what you want to say. And thirdly, that the grand jury is a very important and constitutional factor in our society. Unfortunately, the majority opinion really constitutionalized the grand jury and its status, and said it was not only historical but essential that the grand juries have sources to all information. So in closing, the court said it's up to the Congress and the states to provide protection. So I went to the statutes, and there's 18 of them, I think, to date. Some of them can be dispelled for not being worth anything. But if you look at them, you'll find out that there are generally three large areas that they deal with, and that's what is covered and who is covered. And under who is covered, you got not only the individual, but the media. And then some statutes have special requirements on top of the general ones of who, by defining more narrowly the media or the individual. And then thirdly, the extent of that coverage. I'm not going to go through 30 pages of the detail that I've put together on who does what, the who, and where, and how, but you generally find that the older statutes provide an absolute protection, that the newer statutes go into greater refinement of defining what a journalist or news person is or what a media is. And the newer ones generally also go into qualifications to the privilege, when it can be broken down. Most statutes cover newspersons and newspapers and radio and television. I think New Jersey is one of them that only covers newspapers. But the other media are sort of left out in the cold. Some of them say, yes, we cover magazines also. Some of them go a little broader and say periodicals. Only one covers an idea of journal. And when we talk about whether the freelance writer or the legman is covered, perhaps when you cover the journal, maybe we can argue that guy writing the journal article who really gets out and digs up the good stuff has got a protection too. But under most statutes, only the workaday world journalist, newsman is protected. Now, to the extent of the coverage, I think you might find a few of the statutes interesting. And boy, this is a mess, isn't it? On what they do to limit how far they'll carry the statute. These are statutes that don't have the absolute protection. Probably Rhode Island its statute was passed in 1971, and it sets up a double-part breakdown of the requirements to divest the privilege, and it requires a substantial and compelling need, as was argued before the Supreme Court, and it also has to be shown that the information is not available from another source. Now, the statute will not give privilege to a source where it is necessary to permit a criminal prosecution of a specific felony, or where the disclosure is necessary to prevent a threat to human life. Now, Alaska and Arkansas and Louisiana, they use terms like contrary to public interest. Well, that sort of opens the gates for any sort of exception that the judiciary wants to make, and because nobody has really defined what public interest is. But the statutes alone won't provide any great insight into what the statutes do, because the question still remains, how protective is the protection? And I think only 8 states have had litigation on their statutes, and several of those states have involved absolute press privileges. And as one might suspect, absolute press privileges are not absolute, mainly because the First Amendment, again, is not considered to be absolute, and they'll break them down when there's a conflict between the First Amendment and the Fifth Amendment rights to be indicted by a grand jury and have all the information available. Take Brandsburg, for instance, the man who gave his name to the landmark decision. He tried to claim that he was protected under the First Amendment. He lost, went back in the same state court and tried to argue that he was protected under the Kentucky absolute privilege statute, and he lost. Mainly because Kentucky's absolute privilege statute does not go to the information, but to the source of the information. And Mr. Brandenburg had wrote a story about the 2 men converting marijuana into hashish. He was there and he talked to these people. So the court, through semantics, said, well, Mr. Brandenburg, he's the source. The people who did the conversion, they're the information. So he has to tell. Another thing that happens under press shield statutes would be like in California. Many statutes provide for protection of an employed journalist. As long as you're a journalist, you're okay. When you cease to be a journalist, somebody can knock on your door and serve you a summons or a subpoena to come and talk about what you found out when you were a journalist. And that's what happened to Bill Farr in California. He had complete protection under the California statute. And then he didn't have his job as a journalist. He was subpoenaed and found in contempt of court for refusing to disclose. In 1971, we can be thankful that California amended its statute to provide for such a contingency. So a feeling for the cases will show that absolute is not absolute, and that the qualifications can be made as broad as the court wants to make them, because you have terms like in the public interest. Now, there's an additionally narrowing factor that's emerging on the horizon that will have a profound effect on any drive toward more enactments at the state level, and that's the new proposed federal rules of evidence. They echo a general sentiment in this country by many commentators and courts that privileges are kind of a bad thing generally, because they keep from coming before the court rather relevant and competent evidence that should be looked at in determining how litigation should come out. And there's been a great move to break these down. Now, under the federal rules, there is no newsman privilege, and they specifically state that if a privilege is not provided for in the federal rules, it doesn't apply. So what does that mean? Well, it means that, as already known, in any federal criminal action, state law does not apply, therefore no privilege. Therefore, people can come in and get the information as long as you're in the state level. And by the way, the rules do cover federal grand jury proceedings. Secondly, when there's a federal question involved in your federal jurisdiction, again, state law does not apply in most circuits. And so if you're in a state where you have a privilege, that's too bad, it won't apply. Now, in In private litigation, you might get into the federal court because of diversity of citizenship. Well, there's an old rule that was passed in 1938 by the Supreme Court that says, well, when you have this situation, the state procedural law will have to give way toward the federal procedural law, but state substantive law will apply. Well, there's been several cases subsequent to that case which sort of modifies that, and the latest one was Hannah v. Plummer in 1965, which more or less sets a test that as long as it's the rule that the federal courts are operating under is within the purview of the Enabling Act that gives them the power to have rules, then it's going to be valid against most state laws. So if you look at privilege statutes, you'll find that most of them are in the area of evidence and civil procedure, and that sort of tells you where we stand. The state privilege statute is just that, state. It will probably in the future not apply whatsoever to federal action at the state level. So it's almost encapsulated within that area where very little law is taking place. That if you want to protect newsmen's privilege, I think that it's safe to say that the Supreme Court has virtually gutted any solid First Amendment argument for the time being until the court changes in makeup, which may be for many, many, many years. And that to provide the proper protection, you may not be satisfied with just the state statute, because that's not where the problem lies. The problem lies at the federal government using the media for investigative purposes. So ideally, if you want to, if you argue for a state, if you argue for a privilege, I think that the best route to take would be a congressional privilege from Washington, and to try to fight for as narrow a qualification as you can find there, or not to go for privilege at all.
Thank you very much. I think that now we'll shortchange the reaction from the other side of the panel and get some of the questions from the audience, and then have both sides of the panel respond to the questions as they come up. Okay.
I don't know, there's some sort of irony here, I suppose. We have Mr. Small and myself, two members of the General Assembly, insisting that perhaps we do need a press shield law, and then we have three representatives of the press saying that we do not. I suppose the only certain thing about that is that if the members of the press don't want a press shield law, I can assure you the General Assembly probably won't give you one. We're not in the habit of trying to do good things for people who don't want sentiment exists even in this paradigm. And, I think that that's one of the things you ought to take into consideration. I agree that a federal statute would be best, an absolute shield from the federal level. But I'm not so sure that we should wait around in Iowa or in any other state for that to happen. In fact, what should happen, in much the same way as the development of no-fault insurance, is we ought to be taking the initiative in the state. That's the way the federal model ought to work, to give some impetus to a drive for a shield on the federal level.
Is that a question or is that a statement?
I'd like to respond to it if I may.
All right, let's,
I'd like to ask you a question then. As a civil libertarian, and you say you believe in an absolute shield law, do you believe that, have you weighed really the alternatives here? If an absolute shield law is on the books, and you as an individual are falsely accused by a person who hides behind the shield law, don't you feel that you would have a superior or a larger right to confront that person?
No, I agree that could in fact happen, and furthermore, I suspect that it has happened in the past. I think that what the court said with respect to New York Times versus Sullivan, for example, greatly weakened those who might be maligned by some libel, because you have to prove a malicious intent and the rest of that. And, I can see the possibility of that happening, but it seems to me that if you weigh, the implications of both sides, I'd rather take my chances with the shield law. I at least still then have recourse to other either public investigatory arms like the police department or, a private detector or whatever. It's not as though I have no recourse whatsoever. But in the absence of a shield law and in the presence of the recent Supreme Court decisions, that sort of recourse will not be available to the public who has the right to know.
okay, we're starting to run out of time, so let's go on for a while, but let's make our questions and as short as possible.
Could I, John, I wanted to, I wasn't particularly enamored of that answer, and the point you raised about somebody hiding behind the shield in the libel situation, that's one reason in the bill that we did put together at the state level that to prevent that from happening. The burden of proof, if a person, wrote something which somebody claimed was libelous, then the burden of proof you shift to if the reporter can defend it, fine. But that's you're getting in a different subject area than the question of does he have to, divulge the confidentiality of the sources. If you write something in your paper and you can't back it up, then there's no reason why I can't go after you for libel. I don't see that that's necessarily tied to the shield law concept.
Of course, only if it's libelous. It might be information that's quoted that isn't necessarily libelous, but still very damaging.
I think I've looked at the shield law that they've introduced, and I think Iowa's proposed shield law is probably one of the best ones that I've seen, and I've looked at a lot of them. But I think that under the proper circumstances, that it too, when bumping up against the Fifth Amendment, that it would be set aside and the information or the source, in the case of the Iowa law, would be disclosed. But I think for a shield law, I think it's an excellent shield law.
We've had a question over here.
I would like to comment on that. I agree wholeheartedly.
Could you stand up? I'm not sure that people on the other side.
I agree that the knife of an absolute shield law cuts both ways, and I think that's something we have to keep in mind here. I would like to comment to the comment that was made that Mr. Small's point concerning the changing of the times has not been, or the times have changed now from what they were back when these years and years ago, and therefore we need a shield law now more so than ever. I think that the young man who's the law student
Okay, comment here from Wendell.
Let me just give you a little, hopefully, interesting background on why the press, and I'm coming to our General Assemblyman back here, why the press is afraid of a shield law in Iowa. I'm served as chairman of the ad hoc committee made up of the Iowa Daily Press, the Iowa Press Association, the Iowa Broadcasters, and Sigma Delta Chi. Last summer, these various organizations, meeting individually, decided that perhaps we should have a shield law in Iowa. Thus was the committee put together. On that committee were, and I'll name them, and some of these guys may not appreciate having their names bandied in public because one of them did not want to be known. Hedo Zackerly, the general counsel of the Des Moines Register and Tribune, Ed Breen, who is a lawyer by training and owner of a TV station at Fort Dodge, Ed Jones, who is the general legal counsel of the Iowa Press Association of Des Moines, and his law partner, Dick Thornton, also helped in the drafting of the shield law. Dick Gilbert, who is the executive assistant to Governor Bob Ray, and as you heard Bob Ray in his inaugural address, he asked for a shield law. That was at our request. We had put together a shield law based largely on the New York law. From the media, Rod Riggs and myself, Rod Riggs, who is the editor of the Ames Tribune, and myself from the newspapers, Paul Rhodes of KRNT-TV, Ed, I can't remember your reporter's name, but the Sigma Delta Chi president of the Des Moines chapter.
Larry Fruling?
Pardon?
Larry Fruling?
Larry Fruling, right. Skip Weber and Don Reed of the Press, Weber of Iowa Daily Press and Don Reed of the Iowa Press, and of course Breen as aforementioned. We worked hard. We put a shield law together, a no exception bill. We met several times starting last October. By December, we had one that was pretty well geared up and ready to go. We had the arguments out amongst ourselves, playing devil's advocate and the whole bit. At our first meeting in the governor's office, Bob Ray and Dick Gilbert acted as the devil's advocate, and our law held up pretty good, or our bill, I should say. All the lawyers seemed to have unanimity, let me put it that way. Then Ray suggested, or the governor, I'm sorry, that we get Barney Donaldson, the federal district attorney for Southern Iowa, Craig Beek of the Bureau of Criminal Investigation, Des Moines Police Chief Wendell Nickel, and the sheriff of Warren County, whose name escapes me, from Indianola, who is president of the Iowa Sheriff's Association, and the executive secretary of the Iowa Bar Association. Get them in his office, and let's sit down and roll up our sleeves and either fish or cut bait on a shield law. And gentlemen, from there on, she was all downhill. It was a fantastic piece of I don't know what. This Barney Donaldson is something else, believe me. This guy is great. He took our shield law apart like Grant took Richmond. I can still hear this guy's words, and I hope I'm in essence quoting him correctly. What you people have done with your no exception shield law is create a super citizen. And I want to tell you right here and now that it's an unconstitutional thing, because amongst other things, the Sixth Amendment says a man is entitled to face his accuser. Now how in the hell are you going to get a no exception shield law? With this, we left the governor's office like whipped dogs, because we knew if 7 attorneys sitting around a table could find no unanimity among themselves, what in the hell would happen when you got up on the upstairs in the legislative session, where the whole thing is one of the art of compromise. We had our feelings out. We had talked to Dave Stanley. We had talked with the leadership of both parties, and we had gotten about what their tolerance levels were. And we decided we were much better off with a somewhat fractured, as you've heard our young man, Mr. Fort, say, somewhat fractured First Amendment than with a shield law in Iowa. So that's where the Iowa communications industry stands. We went near the water, we took a look, and now if somebody decided in the legislative session that they would try and come forth with a shield law, you would probably find the Iowa communications industry acting in its several parts, stomping the thing to death, or trying to at least.
That was very good background, Lowell. I'm glad you supplied it.
A question back here?
I'd like to make a statement. First of all, it keeps coming up that...
Let's keep the statements short if possible.
Okay. It keeps coming up that lawyers and doctors and things have the right of privilege of information. I'd like to say that a journalist is not your father's confessor. He's not interested in your opinion of what happened. He's interested in what happened. The fact of what happened, and if he can't prove that fact, then he's got no business being in there. And another thing, that the press has gotten a reputation lately of being a kind of sneaky organization. And I don't think that we need a shield law to help promote this idea that we're sneaky and that we're going to hide behind our position.
Question over here?
Yes, the two cases in particular, Caldwell and Farr, I'm somewhat familiar with the Caldwell case because I know Earl, dealt with very controversial topics. I think, wasn't Farr the Manson case? All right. So you had the Black Panther and the Manson case, which are absolutely notorious. I'm wondering just how many other cases, and perhaps Mr. Hines could answer this, how many other cases would interest a grand jury in this regard? There was a certain amount of publicity seeking, it seems to me, on the part of the grand jury in these cases. I remember that, well, I think I've been told that your crime fund scandal story has been nominated for the Pulitzer by the Register, and that's, I think, Corcoran and O'Shea. And there have been some other very fine investigative pieces by your paper. It seems to me that the problem is not that grand juries and prosecutors are so interested in the material we turn up. My experience as a journalist has been even in sending tape recordings to the Attorney General's office and keeping diaries at their request. They don't act on it. I don't know what law you can pass to get prosecutors to act on some of these things. I can think of 3 or 4 stories right now that have been published here in Iowa within the last year where there's obvious grounds for action on the part of the prosecutors and nothing has been done. I'm wondering, Mr. Hines, if you don't find it it's harder to get them to act than it is not to act.
It's interesting, the only case since I've been managing editor, the only case in which any grand jury or any regulatory body showed any interest in subpoenaing our reporters was a case involving a topless dancer at Boone Isle, as I remember. And it had to do with, and in that case, the request for the subpoena came from the Iowa Liquor Control Commission, which doesn't have subpoena power. Therefore, we didn't pay any attention to that. But I'd be inclined, he mentioned the question of the crime series. Mr. Sorkin's in the back, hopefully quoting me accurately. If that series didn't have anything more to it than an anonymous tipster, it wouldn't have been in the paper because nothing of substance could have come out of that thing without the documentary evidence on which it was based. Now you mentioned several of the cases. Of course, the Farr case, California has a shield law. Peter Bridge case in New Jersey has a shield law. With all the help we've gotten in the way of shield laws around the country, why I find it a little difficult to see why, if the shield laws are such a darn good thing, why is it that the people who have been going to jail happen to come from the states that got shield laws? And I just, but the other question that I wanted to raise was the one that Representative Small raised, the question about the press as being in a risky business, that the Constitution, of course, did give us a special calling above the ordinary citizen in this freedom of the press area. And I agree with that. I think that we are in a risky business. But I would venture to say that the risk is not only that question, but we are, for better or for worse, and I happen to think for better, we happen to work for an institution that is only half of a communication process. We produce information, and the citizens of this country either read it or they don't read it, and it's a voluntary on their part about whether they read it. If they, everything that we do that tends to accentuate the super citizen, the special character, and the special nature of the press, in my view, tends to reduce the credibility of our reports to the people who are going to read them and in a democracy act on them. And if you become so super and so special, you have no credibility left with the only people who can do anything about the information that you're producing, that is your readers. This is the last time anybody has to buy a piece of literature is the day he steps out of the last school. They're the only places where they require you to not only to buy books, but in the case of the universities in this state, they require you to buy the newspaper through your student fees. We don't have that in our enterprise here, and I'm glad that that is the case. And anything in the way of special help from the legislature, with friends like that, we don't need too many enemies, I can assure you, if the legislature is going to help us out. And I would hope, for instance, that Mr. Sorkin's coverage of the debate in the legislature in the last few days about the use of the traces system, I would think that that would be a perfectly good example of an issue that was brought up out of investigative reporting and became an issue because of the enterprise by the reporters involved, of course, and by the paper. There's nothing involved in that needs a shield law protection, and it didn't. And the fact that we don't have shield law protection certainly didn't make us shy about getting into that sort of thing. I just think that in this particular case, I pass when everybody wants to make me a special citizen in Iowa. Thank you.
One more question, Norman.
Chairman, it seems to me that the impetus for a shield law has come from, not from, as was suggested, individual citizens who've been maligned by the press and want to get back at them through a libel or slander action. The shield law, the impetus for it, comes from the abuse by government of the coercive process with respect to newsmen because they've been critical of government. And if, as you suggest, newspapers are and their reporters are so great, I would assume that in the event that a private citizen had been maligned, that they might waive their privilege and testify on behalf of that individual. But the problem is the coercive effect of government when newspapers are critical of government and its operations and not critical of individuals, as I understand the reason.
Would one of the panelists like to respond to that?
Yes, I'd like to respond. In the question about criticizing government, we have a case, I think, involving it was a potential jailing of an LA Times reporter, but he didn't have to go to jail because the source that he had given his word to said it didn't make any difference and he could give the source. But if I read the things correctly, the significant reporting in the Watergate case in this particular thing was not done by the LA Times, but was done by the Washington Post. And there's nothing that's stopping the Washington Post. There's no problem there as far as the Washington Post is concerned about vigor and enthusiasm towards criticizing government in this case. The one case that involved a question of going to jail was by a reporter who was doing a very minor league job in that type of criticism. So in that case, you don't need the Washington Post hasn't needed a shield law to work on the Watergate case.
I think we have to realize something that the majority in Brandsburg didn't realize, well, probably chose to ignore it, is that they referred to a couple of law review articles where they tried to ascertain the adverse effect of forced disclosure. And, it's sort of unscientific because how are you really going to find this sort of information out? So the court says, well, let's see, 8 to 11% says there's an adverse effect. Well, that's not enough. What we're dealing here is the First Amendment. And the First Amendment doesn't require you to say, well, only 800 out of 10,000 people are affected, so forget it. You look at the 800. And I think Mr. Hind is right. A lot of newspapers don't need the Press Shield law. And when they don't need it, it doesn't apply. The law is designed to apply when it's needed. And it's needed when you're interviewing Black Panthers who make very general statements about their dislike for Mr. Nixon. And then you got the federal boys running in there with a subpoena saying, we have a right to know who said that because under this law we have to find this guy and prosecute him. But it's an ideology, and it's persecution by the government. And if you're talking about something that you have all the sources printed out there, nobody's going to raise the issue. And if they do, your party don't care. It's when you have a story that you want the people to know about. You want the people to get on the inside of the Black Panthers or inside of the drug culture to see why they do these things, why they think this way, so people have a feel for our society and the subcultures within it. And when that happens and the government starts coming in, that's when the people are deprived of information.
We've been, I think it was columnist Mr. Dooley who said the function of the press was to comfort the afflicted and afflict the comfortable. We've been talking about in the first panel, how do you comfort the afflicted by giving them access and a chance to express their views. We've been talking in the second panel of how do you afflict the comfortable. Do you afflict the comfortable by seeking some protection through a shield law, or do you afflict the comfortable by not asking for any kind of special privilege or something that might be considered special privilege and going after them hammer and tongue? If there is some conclusion to be drawn from either panel, it escapes me at this time. But I want to thank the audience for its participation and thank the members of the panel who have done a great deal of work and have, I think, done an excellent job of exploring these very complex and difficult and exciting and significant issues. I'll now turn the meeting back over to John.
Make one thing perfectly clear as I came here, that I wasn't hearing this thing anymore, but I think
But let's talk about the way. Public information that a judge had ordered not to make public, and he didn't order Fawn not to make public, he ordered officer.
Before our case does get into the issue of disclosure, you guys saw some information. I see your point. I mean, under the ABA concept of free, press, fair trial, bar is a question of the case. They're amended to do two things, I think. One, to cover people after they left. If you want to stay, I can do that.